Hi students, I am Professor Kshitij Bansal and I teach at Jindal Global Law School. We are today going to discuss internally displaced persons and the United Nations guiding principles on their internal displacement. What are we going to learn out of this briefing? Introduction to the concept of internal displacement people, number one. Number two, you will understand the international context of protection of internally displaced persons in accordance with UN rules. Internally displaced persons, which we are going to refer to as IDPs, have long been subject to atrocities and have become collateral damage in conflict areas. A majority of IDPs are civilians who are incapable of protecting themselves and rely on the state for the protection. When the state is in political disruption, they are the first to be affected. Understanding their position became increasingly important and ultimately led to the passing of UN guiding principles on internal displacement in 1998. Who are internally displaced people? Internal displacement is the coerced movement of persons within their country. The UN guiding principles on internal displacement define internally displaced persons as persons or groups of persons who have been forced or obliged to flee or to leave their homes or places of habitual residence, in particular as a result of or in order to avoid the effects of armed conflict, situations of generalized violence, violence of human rights, or natural or human-made disasters, and who have not crossed an internationally recognized state border. The involuntary nature of their departure and the fact that they remain in their own country are the two main elements determining who is an internally displaced person. Why were the United Nations guidelines created in this regard? War has always been one of the main reasons people are forced to abandon their homes. They cause massive displacements in the population. As Ruth Lubbers, United Nations High Commissioner for Refugees, stated in 2001, refugees continue to flee persecution in countries at peace, but armed conflict is undeniably the greatest cause of refugee flows today. The nature of conflict has also changed with the proliferation of internal, ethnically or religiously based struggles in which displacement has become an objective rather than merely a consequence of war. By the end of the Second World War, the number of people who had fled their homes, discreetly labeled displaced people, was estimated to be 30 million. International law and the protection of IDPs, no universal instrument specifically addressed the plight of IDPs until 1998, when the UN General Assembly and the UN Commission on Human Rights took note of the guiding principles on internal displacement. While these guiding principles do not constitute a binding instrument, they have received large support from the international community. For instance, in 2009, the African Union adopted the Kampala Convention on IDPs. This regional instrument is an important step forward in the protection of and assistance to IDPs in one of the continents most affected by displacement. IHL contains many provisions concerning the prevention of displacement and protection of IDPs, mainly in Geneva Convention 4, the additional protocols 1 and 2, as well as in customary international law. States have the responsibility to implement these protections in their internal legal framework. What are the UN guiding principles on internal displacement? The United Nations, in its capacity of an international organization, constituted the guidelines on internal displacement in the wake of an increasing number of conflict-ridden zones. The guidelines provide direction to the international community. Individual nations faced with the problem of internal displacement and all other intergovernmental and non-governmental groups. While no international convention on the rights of internally displaced persons exist, they enjoy the same human rights as all other people within their own country of citizenship or residence. These rights may be articulated in the domestic constitution and legislation, as well as international human rights instruments and customary law. In situations of armed conflict, moreover, they enjoy the same rights as other civilians to the various protections provided by international humanitarian law. The guiding principles on internal displacement restate in explicit terms the rights of IDPs that are implicit in the more general guarantees of existing international human rights and humanitarian law relevant to the internally displaced people. The principles identify rights and guarantees relevant to the protection of persons from forced displacement and to their protection and assistance during displacement as well as during return or resettlement and reintegration. General principles disseminated by these guidelines are as follows. The general principles as created by the UN guidelines are: internally displaced persons are entitled to equal rights and equal obligations as any other persons of the state. No state or no organization is permitted to discriminate against or withhold protection from IDPs on the basis of their race, religion, political affiliation, age, sex, ethnic origin, or nationality. Universal application of the guidelines is owing to the fact that they are grounded in international law. They represent customary law, international law, and international humanitarian law, which are all binding sources of law. The principle that sovereignty means responsibility is woven in the guidelines as it assigned states the duty to provide security, welfare, and liberty to its citizens. The guidelines, in fact, reinforce sovereignty by assigning the duty to protect its citizens to the state. Right to seek and enjoy asylum is provided to internally displaced persons who cannot be prevented from seeking refuge in other countries. The country of origin cannot restrict them from fleeing to neighboring countries, and the host countries cannot use the guiding principles as a justification for denying refuge to the IDPs. Protection from displacement is the next. Preventing displacement. Principle 6 of the guiding principles defines arbitrary displacement as follows. When it is based on policies of apartheid, ethnic cleansing, or similar practices aimed at or resulting in altering the ethnic, religious, or racial composition of the affected population. In situations of armed conflict, unless the security of the civilians involved or imperative military reasons so demand. In case of large-scale development projects which are not justified by compelling and overriding public interests. In cases of disasters, unless the safety and health of those affected requires their evacuation, and when it is used as a collective punishment. These are all reasons and definitions which would lead to an arbitrary displacement. The right to be protected from arbitrary displacement is a universal human right. Arbitrary displacement leads to being denied the right to choose one's residence as well as restricts their freedom of movement. The absolute prevention of displacement is necessary in ethnic cleansing and apartheid where it is used as a collective punishment. Even in cases where displacement is necessary, the guidelines emphasize the fact that it should be temporary and solutions for it must be implemented immediately. One of the key requirements for the prevention of arbitrary displacement is to consult the parties in conflict. Minimizing displacement and its effects has several steps. These steps can be taken to make displacement less harmful. The process of displacement can be made more comfortable by paying special attention to the needs of women and children. Also, the location of settlement site can be made as close to the home community to reduce the expense of the displacement. Protection during displacement is another important aspect, enhancing physical security and freedom of movement. The state is obliged to work towards the preservation of the basic rights availed to humans. The right to life, to dignity and integrity are those which are often threatened in situations of war or conflict. Protection against arbitrary arrests, against forcible return to one's war-ridden home, are other rights availed to internally displaced persons. Another principle which the guidelines prescribe are that the state must work towards preserving family as a unit where displacement should be done while maintaining family unity. The state must work towards reuniting separated families and must pay special attention to the rights of children. Protection of economic and social and cultural rights would be the next aspect in the protection of IDPs during displacement. All over the world, displaced persons suffer from poor living conditions ranging from poor sanitation, potable water, and housing. States should ensure the proper treatment of the displaced persons and assist them in living lives of a reasonable standard of living. The guidelines emphasize employing women in the distribution of basic supplies in the relocation area. This could inculcate women as decision makers in society and uphold the importance of gender equality in the times of conflict. Other rights that IDPs are entitled to include the right to medical treatment, such that hospitals cannot deny medical treatment. Also, the right to work and own property cannot be taken away from IDPs. Let's now talk about principle of humanitarian assistance. When state authorities are unable or unwilling to provide assistance to the displaced, international organizations have the right to offer their services and to enjoy rapid and unimpeded access to the displaced. Humanitarian assistance has a wide protection capacity as its aim is to address the urgent needs of the target populations, thereby improving their human rights situation. Yet, if the planning and delivery of humanitarian assistance are not guided by protection objectives and basic principles, the safety and dignity of civilian populations can be put at serious risk, and the humanitarian character of assistance can be undermined. Conscientiously planning and delivering humanitarian assistance through a protection lens can greatly expand its protection capacity. Therefore, humanitarian assistance shall be provided consistent with the principles of humanity and impartiality and without discrimination, and states should take into account and work to address their protection. For instance, while the Syrian government has failed to and was even reluctant to provide humanitarian assistance to refugees, international aid agencies attempted to provide that support. Unfortunately, the government prevented them from being able to respond to the needs of all IDPs, irrespective of their locations or political allegiances, in conformity with the humanitarian principles of the neutrality of humanitarian assistance. The Syrian authorities have severely restricted the work of international humanitarian agencies and, except for a few cases, have prevented them from delivering aid to rebel-held areas across front lines and international borders. What about return and resettlement of the IDPs who had gone out of their original residence and places of habitual residence? Internally displaced persons have the right to return to their home community or settle in their host countries voluntarily. Right to equal treatment is provided to those who have returned or resettled. Also, people have the right to claim their property before they left or compensation of it. In this manner, the guidelines make sure that the internally displaced persons feel accepted in the society they have resettled in or in their home community post their return. It helps them resume their lives post the conflict. In all of this, what are the responsibilities of national authorities and international organizations? National authorities have the primary responsibility to provide protection and humanitarian assistance to IDPs within their jurisdiction. Please see Guiding Principles Clause 3, Subclause 1. These duties may be understood to be threefold: to respect, to protect, and the duty to fulfill. The duty to respect requires the state to ensure that all agents of the state act in compliance with human rights law and refrain from any act that might interfere with or impair the exercise of rights. As an example, the state must not restrain freedom of movement. People must be allowed to flee to safer areas within or outside the country, and IDPs must be able to move freely in and out of camps and settlements. The duty to protect, which is the second duty, obliges the state to take all necessary measures to prevent or to put a stop to any violations of rights by third parties, including other individuals and groups. The state must also investigate, prosecute, and punish violations of rights and ensure that victims and survivors have access to an adequate, effective remedy under domestic law. As an example, if the state is aware or reasonably should have been aware that women are being raped or that children are being recruited into a guerrilla group, but does not take action to prevent and put a stop to such acts, it would have failed to fulfill its duty to protect. The duty to fulfill, which is the third duty, requires the state to take all possible measures to ensure that individuals under its jurisdiction are able to exercise their human rights. This requires the state to put in place a legal and administrative framework that respects human rights and builds national capacity to support the implementation of rights. As an example, ensuring the right to a fair trial requires that an effective judicial system be put in place, and ensuring the right to freedom from torture requires that police and prison guards are adequately trained and supervised. In other words, to ensure the realization of rights, a state must often invest its resources in its own internal processes and systems. International humanitarian organizations and other appropriate actors and stakeholders have the right, and many argue the responsibility, to offer protection of and assistance to the internally displaced where their state is unwilling or unable to. Consent to such an offer should not be arbitrarily withheld by the state, and all authorities concerned should grant and facilitate the free passage of humanitarian assistance and facilitate unimpeded access to the internally displaced people by these international organizations. Let us talk about an interesting case study in this regard: Darfur, the region in Africa perpetually hit by internal strife. The Darfur emergency has been called world's worst humanitarian disaster by UN Under Secretary General for Humanitarian Affairs Jan Egeland. As in Bosnia and Herzegovina, a decade earlier, the international response in Darfur has largely focused on providing emergency relief. There are more than 11,000 humanitarian workers on the ground in Darfur, but fewer than 100 staff with protection responsibilities, and only a few thousand lightly armed African Union troops with a weak mandate for protection. The crisis in Sudan's western region, Darfur, began in 2003 with an attack on government military outposts by insurgents of the Fur, Masilith, and Zagawa tribes. Their immediate grievance was government favoritism towards Arab herdsmen who were increasingly encroaching on black African farmlands. More fundamentally, the rebels saw an opportunity in the ongoing North-South peace process in Sudan to demand for Darfur the same power and wealth sharing arrangements that African tribes in the south and the center of the country were obtaining from Sudanese national authorities. The government resorted to violence and murdering 70,000 men and deliberately displacing 2 million people, while 200,000 became refugees in neighboring Chad. Succumbing to the pressure by the UN, the government lifted most of its restrictions on humanitarian organizations and signed an agreement with the UN. For less progress has been made in the area of protection. When the governments refused to comply, and in this case refused to comply with Security Council requests to stop attacks on the civilian population, little or no effort was made to enforce resolutions. The government failed to disarm the Janjaweed, seize helicopter assaults on villages, and end the forcible returns of internally displaced persons to their home areas. This led to regional cooperation working towards Africa helping Africa. It would be very, very pertinent and correct to conclude that this module has introduced the readers and listeners to the guiding principles as laid down by United Nations, which govern the protection and rights of IDPs right from their time of being transferred until the time of coming back to their country for resettlement. It furthers the intrinsic right of equality at all times, even at the time of conflict. Firstly, the reader is introduced to the concept of internally displaced persons and threat being posed to them. Consequently to the same, the UN guidelines were laid down to seek protection and of displaced people. The module also states that treaties which govern to safeguard the refugees and internally displaced people. The most important guideline confirming to ensure the resettlement of the IDPs is also specifically referred to. It is the utmost duty of the government and non-governmental agencies to ensure the protection and rehabilitation of IDPs. The module closes with a case study of an internal displacement that took place in Darfur. I sincerely hope, with the help of this case study and with the review of UN rules and regulations and treaty obligations, you have got effectively introduced to the regime of protecting internally displaced people under public international law. Thank you so much for listening.